Thank you very much for joining us today. Welcome to this webinar on delivering major infrastructure, justifying the land acquisition strategy. My name is Richard Turney. I'm chairing the session today. This is the second in a series of 5 webinars, which we hope will help you through the land acquisition process, focusing on the delivery of major infrastructure. And as the government looks to infrastructure investment as a major macroeconomic tool, we hope it's both timely and useful. Thank you for joining us. Before I introduce the speakers, a few housekeeping points to note, please. First of all, your microphones are automatically muted, so you will not need to adjust your local settings. Please do ask questions. You can submit them in the Q&A section, which you'll find somewhere on your screen. We'll endeavour to answer as many as we can. Apologies to those that we don't get to. The webinar is recorded. It will be published on our YouTube link later, and you'll receive a link to that. If you lose connection, you can just rejoin through the original invite link, so please do that. So today I'm joined by my colleagues Yaaser Vanderman, Elvin QC, and Matthew Fraser. Just by way of introduction, Yaaser is a leading planning law junior. He recently promoted the East-West Rail Scheme Transport and Works Act order, and works across major infrastructure, including airport expansion and the quadrilla fracking litigation in the High Court. And he's going to give us an overview of justifying the land acquisition strategy. We'll then turn to Elvin to address the compelling case, human rights and alternatives. I suspect David will need little introduction for many of you. Put simply, he is and has been for some time one of the leading practitioners in this field. And indeed, he taught many of us how to do it. He led the team promoting Crossrail through Parliament, which aside from seeking authorisation for that scheme, was one of the most complex land acquisition processes in recent history. And of course, he's also acted on some of the largest regeneration schemes, both in promoting the order and in dealing with compensation claims. He's going to talk about some of those, but they include Liverpool 1, Croydon, Whitgift, the Alma Estate, and most recently, the Redcar Steelworks CPO for the South Tees Development Corporation. And David was supported on the Redcar case by Matthew Fraser, who is another leading planning junior, and he's our final speaker. Aside from his recent work in the North East, Matthew acts for HS2 and the DFT in defending a major compensation claim arising out of the acquisition of land at Euston Station. And his talk is going to focus on the tactics for CPO objectors. So with that introduction, I'm going to hand over to Yaaser to give the first paper.
Good afternoon, everyone. Really glad that you could all make it today. I'll be kicking off, as Richard said, with his kind introduction, with an overview on justifying the need for land and rights. Part 1 of this series of webinars on Tuesday this week focused on setting the strategy in the first place. And you may have heard, if you were there, David Nichols touch upon some of the issues that I'll be talking about today, but he was talking through the prism of starting with a clean slate, an inwards facing method of analysis. My focus today is on justifying an approach once decided upon, more of an outward facing method of analysis. So these are the topics that I'm going to be talking about. Specificity, the need to be specific about what land is required. Permanence, justifying why the acquisition has to be permanent rather than temporary, or rather why simple acquisition of rights would be insufficient. Evidence, the need for evidence to justify each plot and indeed each part of the plot. And finally, I'm just going to touch on material detriment. I know that Richard will refer to it as well when discussing promoter tactics. And Richard kindly referred to this in his introduction. And in order to bring this talk to life, not that it needed to, I thought it would be useful to speak by way of reference to the big scheme that I did last year, East-West Rail 2. I was lucky enough to be instructed by the promoter Network Rail with Tim Mould. And this was a major part of the £1 billion project to connect Oxford and Cambridge by rail. The inquiry last year took many months, where we, no word of a lie, all physically sat in a room together for days, weeks and months. And that now seems like a lifetime ago. And of course, it was all done under the Transport and Works Act 1992. And so I'll be using this to exemplify some of the points that I come to make. Starting then with specificity, it goes without saying that if you want to acquire someone else's land, you need to be very specific about exactly what land you acquire. Otherwise, very obviously, the landowner doesn't know whether to object or not, the potential grounds for objection, how much compensation they can claim, etc. And you see there part of the Acquisition of Land Act 1981, which talks about the necessity for this. And it's probably actually easier to show you rather than explain this any further. In relation to the Acquisition of Land Act specifically, as you can see, this is the 2004 regulations, there is a prescribed form for you, and it looks exactly like this. And you can see that it talks about the extent, description, and situation of land, and it also talks about number on a map, which would be very helpful in accompanying this schedule, as well as qualifying persons, owners, those kind of details. And where it's a large project, you'll often see a book of reference and deposited plans. And voila, this is part of the book of reference for East West Rail 2, quite a large document by the time we've got to plot 1171. And you'll see the description is quite specific. And my favourite part is where it describes to 60,071 square metres or thereabouts. And so that there's no doubt about what that actually refers to. This is a page from the deposited plans, which show you the extent of plot 1171. You probably can't see it, but the 1171 written out, but it's the light grey area towards the bottom of the plan. And this is located east of Woburn Sands in Bedfordshire. And in the top right-hand corner, you certainly can't read this, but it says that plot 1171 is one of the plots for which unrestricted powers to acquire land being sought. So that shows anyone looking at the plan or anyone concerned exactly which land is being sought. Moving then on to permanence. You have to justify why the acquisition has to be permanent rather than temporary, or why simple acquisition of rights is not sufficient. And of course, CPOs at the moment only allow permanent acquisition of land or acquisition of permanent new rights. With Transport and Works Act orders and DCOs, however, temporary possession and rights are a possibility. But keep an eye out on the 2017 Act, the Neighbourhood Planning Act, which does allow for temporary compulsory possession of land in England and Wales, but no, it's not yet in force. What seems like a statement of the obvious from the DCLG guidance, and is albeit within the context specifically of the Planning Act of universal application, is the need to have a clear idea of how you intend to use the land that you propose to acquire. And once you undertake that exercise, it should be pretty straightforward to determine and then justify why you need the land permanently as opposed to temporarily. For example, if the land is needed because you want to put a railway line on top of that land, clearly that requires permanent acquisition. If the land is needed as a construction compound, a temporary arrangement may be more possible. And then there's your trickier issues, such as ecological mitigation, that might need to be there for a good number of years and managed, but maybe not perpetuity. And we'll have a look at that kind of issue in a moment. In terms of case law, this was an issue that was just briefly touched upon in the FCC case, almost by way of passing, but that by no means diminishes the importance of the point. This was a challenge to DCO for an energy from waste plant in Bedfordshire. And in the High Court, Mr. Justice Mitting had said he found it difficult to think of circumstances in which there would be an urgent need for development as set out in policy, but no compelling case to justify compulsory acquisition of land. And indeed, what you see here in the Court of Appeal is both parties disagreeing with that assessment. And in fact, in David Blunder's skeleton argument, he's acting for the Secretary of State in that case. He gave examples, and you see one of these examples in which what Mr. Justice Mitting might have said might not be true or might not hold, is the acquisition of a right over land rather than this acquisition might suffice, i.e. the permanent acquisition versus acquisition of rights divide. And so in other words, you better be able to justify permanent acquisition, otherwise you may not be able to establish a compelling case. And I think this is something David will speak to later on. Another issue you get is situations where the consent might be time limited, but permanent acquisition of land and extinguishment of rights is sought. And in the Jones case, involving a challenge to the North Wales Wind Farms DCO, Mr. Justice Lewis found that this was acceptable in principle. Dealing first with Article 18 of the order, that provided for compulsory acquisition of rights, the panel considered that was justified, and indeed that finding was not challenged. Moving on to Article 23 of the order, that was challenged, and that provided for the permanent extinguishment of rights over land. And we see in the judgment here that Mr. Justice Lewis found nothing objectionable about the fact that consent was only to last 30 years, whereas this extinguishment would be forever. But of course, there has to be a good reason for it. So then going back to our plot 1171, Network Rail wanted this plot as an ecological compensation site. You remember the light grey area we looked at earlier, and specifically for the translocation of great crested newts, whose pond habitat nearby was going to be lost. Now, it was intended that this compensation site would be subject to a 30-year maintenance and management plan between Network Rail and the landowner, and it was assumed that this land would then be restored to the landowner following construction of the compensation site, subject to legally binding provisions which would require the site to be maintained and managed for the 30 years. And so you may ask, why was permanent acquisition being sought at all? And the answer is because it wasn't clear how able and willing the landowner was to fulfill the monitoring and management obligations. So although this pragmatic approach of resolution would be attempted, the order powers were still necessary as a backstop in the event that agreement could not be reached with the landowner. Then looking at evidence, the need for evidence to justify each plot, and indeed each part of each plot, that will often require expert evidence depending on why the land is needed. For example, just looking at each part of the plot, part of the equation for now, in East West Rail there were lots of objections about land that was being acquired for compensatory flood storage areas. And some of those objections were that the areas didn't need to be so big, i.e. not all of the plot was necessary. And what you need to be able to do in that situation is put out an expert that can explain why the whole plot is needed. And often it will come down to which expert inspector agrees with. Moving on to a slightly different point, this is part of the route near Winslow. You see the railway line travelling east to west. The bright yellow either side of the north and south of the railway line is grassland. And on the north side of the line, you see an almost peach-coloured area, a peach or salmon. And Network Rail sought to acquire that area again for a further ecological compensation site. And unfortunately, Gladman were not very happy with that because that was part of the land which had been granted a draft allocation of housing in the emerging Vale of Aylesbury local plan, and had the direct effect of reducing the number of dwellings from 235 to 215 on that land. Now, in those circumstances, it obviously wasn't sufficient for Network Rail just to use the ecological compensation site trump card. Without more, it needed to evidence its position. So why was the land necessary? You see the justification set out here in the environmental statement. B10 is the site in question. And the answer is ponds for great crested newts, of course. And Gladman objected to the inquiry. Various arguments were made, including that there was no loss of aquatic habitats within 500 metres of this compensation site. So the implication being that this wasn't being used for compensation, but for enhancement, and that was not a good enough reason for compulsory acquisition. And that's the point at which you need your experts to earn their keep. And all I've done here is copy out a section of the rebuttal of our expert. It was excellent. Dr. Stephanie Ray, who was excellent ecologist and witness. The detail in here isn't important. The point to draw out is that you need to justify not just what the land will be used for, but why. And when you have well-resourced and well-advised objectors, the justification has to be watertight. No pun intended. Moving then very briefly onto material detriment. I'm going to touch on this briefly before Richard talks about it some more. First, what is it? A useful précis here in the VOA's Land Compensation Manual. Just give you a moment to read it. The key part being that it applies when a promoter only wants part of a property. And here you see MHCLG guidance in the context of compulsory purchase. And underlined at the end, you see the kind of test that will be applied, i.e. does it cause other land to be less useful or less valuable to some significant degree. This is a list of some examples of the legislation which include these material detriment protections. And that example at the end is one from the East West Rail 2, the order for East West Rail 2. Because in a linear scheme like that one, there will be many examples of parts of someone's land being acquired. And as a final example, this is an example of East West Rail and sort of thing. Poor Mr. and Mrs. X and family who lived at Station Cottage, denoted by a massive red arrow, but whose garden was going to be cut in half because plot 0221 was required for the scheme. Now, the fact that some land you take will have an additional adverse impact on a larger estate is the kind of thing you have to watch out for and be able to justify, as already discussed. But as I mentioned, I think Richard will come onto this from the promoter's perspective later on. But that's all from me. I'll now hand you over to David.
Good afternoon, everyone, and thank you, Richard, for the introduction. I'm going to deal firstly with the issue of the compelling case, which of course applies to all CPO cases. And I've begun with what's quite a well-known quotation from the then Mr. Justice Laws in Chesterfield Properties, by just emphasising how important property rights are that are going to be acquired. And although a Wednesbury test applies, nonetheless, emphasised by policy, which is long-standing, the compelling case in the public interest to justify the acquisition, the rights of property do seem to require particular justification, or at least the courts will scrutinise it that much more carefully. And you can't rule out, in many of these cases, the human element, which I'll come back to in a moment. It's a key tenet of national policy, and I've quoted from the latest guidance, paragraph 12, very well-known statement of policy. It's appeared in circulars and guidance going back for many years. The compulsory purchase order has to show that there's a compelling case in the public interest. In other words, the public interest must justify overriding private property rights, and that reflects, it is said, the Human Rights Convention. So far, so good. Tied in with that is the need to justify the case. And here you've got more details set out in paragraph 13 of the guidance, which I'm sure is well known, and I'm not going to read it out. But it makes the common sense point that the better the justification, the more comprehensive the justification, then the better it will be in terms of demonstrating the compelling case. There is no specific level of justification, and you have to reach a judgment on the particulars of an individual case. Some schemes which have many elements will require an overall justification. Big infrastructure schemes, the South Tees Steelworks CPO that Matthew and I did in February, which was confirmed in April, it was easy to show the compelling case to the extent that the steel making had ended at Teesside, massive unemployment, massive underuse of land, derelict and polluted land, which millions of pounds are being spent in order to remediate and keep safe. So showing the public interest in some cases is fairly easily achieved and is done for you often by a lot of government policy documents or local policy documents. But in any event, you have to tailor it to suit the individual case. And making again the clear point, you have to justify how you intend to use the land. And as a matter of sound practice, I've always regarded it as essential when you're putting forward on behalf of an acquiring authority, whether it's government or local government, you need to justify each and every parcel of land that you are proposing to acquire or over which you're seeking to acquire land interests. And I've often, in cases, got the witness dealing with the compulsory purchase issues, usually dealing with the property objections as well, to produce a schedule which goes through each parcel or each set of rights which are sought to explain how that is justified, what is the reason, linking it to the justification for the scheme as a whole. And of course, tied up with that are the need to show that there are no impediments and that funding's available up to a point. There are no obvious reasons for withholding. All of this is tied into showing that there's a compelling case and that it's capable of implementation. Of course, you'll be aware, and I'm again setting out well-known principles, there are details in Tier 2 of the guidance, what used to be the appendices to the CPO circular, but it's now in Tier 2 for different sorts of CPO by different bodies. The most familiar one is Section 226, the Section 1 guidance, but equally there's guidance for Homes England, urban development corporations and the like. You have additional requirements in those Tier 2 cases, and the well-known ones in Section 2 for Section 226 cases, fitting in with the adopted local plan or with the draft plan and the MPPF, achievement of well-being in its various aspects, whether or not there are alternatives, in other words, whether you could achieve the objects of the CPO by other means. I'll come back to alternatives in a moment. Potential financial viability, and that will again turn on the circumstances. Usually a general indication, and if it's a CPO being promoted on behalf of a private developer, for example, Croydon Whitgift, where that was being promoted by private developers, and indeed Liverpool 1 was being promoted effectively by Grosvenor through Liverpool City Council, but it was a private development scheme in essence. Usually you need to have some sort of confirmation from the developer that the funding's available. They will rarely go into detail over viability and the details of funding and their own viability exercise. And we had a lot of arguments over that at Croydon. But ultimately, if you can show that the company has procedures, that it has looked at viability issues, that it's had it audited independently by advisors, you can deal with that, as it were, indirectly, and you don't always need to produce straight viability calculations. Public funded cases need to go further, and in the Teesside case that Matthew and I have just finished, there was a need to go into some detail because, of course, it's a publicly funded scheme, at least to pump prime the private development, which is then hoped to take place because of the millions and millions of pounds being required for remediation and keep safe, and to parcel up the infrastructure in order to make development attractive. UDC cases have got similar requirements, including requirements as to whether you're best going to achieve regeneration by acquiring it by the UDC itself. Similar things will apply to statutory development corporations, though there's no specific guidance as such. In DC cases that I've done, we've always assumed that these criteria should apply by analogy, and that has certainly been accepted by the Secretary of State. Number of authorities, just so you have a useful list. Prest was the starting point in more modern times, although there Lord Denning set out at great length something which appeared to be a stricter than Wednesbury test. However, the Court of Appeal in De Rothschild revisited this and said, well, no, actually it's still only Wednesbury. But as Mr. Justice Lord said in Chesterfield, of course, it's Wednesbury with a high degree of scrutiny to ensure that property rights are being inquired for proper reason. And there's no reason to assume that if the compelling case in the public interest test is properly observed by the acquiring authority and properly puts forward its case on that, then that will satisfy the high degree of scrutiny. You've got clear indication by both the then Mr. Justice Sullivan and Mr. Justice Harrison in the Tesco and Bexley cases, which stood either side of the Human Rights Act coming into force, that the application of the European Convention added no substance to the compelling case test, and that's been more recently approved by the Court of Appeal in the Hall and Clays Lane case. And indeed, you can meet the compelling case, even though in some cases you may not have as robust a case as others. The Grafton Group CPO, which involved the Port of London, was confirmed despite the fact that planning permission for what had thought to be the CPO scheme had been refused. It was refused by the inspector, but it was found that there were sufficient prospects of a better scheme coming along, although no detail was presented of that matter, and Lord Justice Laws, as he then was, rejected the challenge to the CPO. The first line should say offer, not that strange mark there. But he simply confirmed, applying Wednesbury, that the inspector had scrutinised the position and had been entitled to find that the compelling case could be met from the indications from his familiarity with the proposals and what might come along, that another scheme would come along which satisfied it. That is slightly surprising given what he said about the high degree of scrutiny in Chesterfield, but it does show that these cases often turn very much on their own detailed justifications. Some examples, I'm afraid they're all from my scrapbook. What was called the Paradise Street development area, it's now Liverpool 1, it's now the centre of the city centre retail offer. It had an accompanying CPO, the Sedan Street CPO, to acquire land for a new fire station, which had to be relocated from the area of the major development. It was a major, comprehensive, privately led scheme, which had been preceded by a design and developer competition of nearly 19 hectares of the city centre, which revolved around the rather failed 1960s elements of development in Paradise Street, where the bus station used to be, and there was a rather depressing hotel and a lot of concrete. Now the very successful Liverpool 1. It was supported by very recent plan policy, and the major alternative to the scheme, which was brought by the Walton Group, and they sought planning permission for a scheme just on the park area to the west of Paradise Street. They said that was a preferable alternative to the scheme as a whole. That had been kicked out on appeal by the Secretary of State just before the CPO, and the scheme therefore had had the benefit of strong policy support, rejection of the alternative scheme to the scheme as a whole by the Secretary of State, and 5 years of working up where it reached inquiry September 2003, and there had by that stage been significant property acquisition to support the CPO scheme. So you can see why the inspector had no difficulty and the Secretary of State had no difficulty accepting a compelling case. Indeed, planning permission had been granted. It was granted in December 2002, at the same time the council then went on to resolve to CPO the site. It's a complex development agreement and protection for the Grade 1 listed Blue Code Centre and its regeneration. And it was very fortunate that I think a day or two before I opened the case on behalf of Liverpool and Grosvenor at the inquiry, John Prescott, the then Secretary of State, announced the designation of Liverpool as European Capital of Culture in 2008, which coincidentally was the date when the development was supposed to open. So we did have a lot of cards stacked in our favour, not least the fact that Liverpool was seriously leaking retail expenditure and shoppers to other less sustainable locations in the northwest and needed major regeneration. There you have the inspector rejecting the alternatives. It's fair to say that a lot of landowners said, well, we can do the development on our parcel. I think there are over 250 parcels of land in the CPO. And the inspector rejected that on the basis it would cause delay and uncertainty. And indeed, we produced a plan to the inspector sometime during the inquiry showing blanked out from the development area, the scheme area rather, those properties where the owners had said, oh no, we can develop it ourselves. And it looked, frankly, as if someone had machine gunned the scheme plan because it would have taken large chunks out. And it would have caused significant impact on delivery and certainty. There it is, that's the PSDA master plan. It included not only the central part of Paradise Street, which you see running up the middle, it also included a few peripheral areas, particularly to the east of Hanover Street, you see on the right-hand side, but it was thought better not to have a more comprehensive development of a slightly wider area, and and that was upheld by the inspector. It was all tied down with step-in rights and the like in the development agreement. This is the as-built plan, which you'll see is remarkably similar to the master plan. There were some changes. The hotel and the car park were swapped around and a few other tweaks were made, but all within the terms of the schedule to the CPO, and thus within the principle that Mr. Justice Ouseley described in Argos of ensuring that the CPO fell within the powers, but was not tied to any specific planning permission. Indeed, the permission was varied after confirmation of the CPO to enable those matters that I've just mentioned. But I'm told it has been very successful. Crossrail, a hybrid bill, ran from February 2005 to Royal Assent in 2008. We had select committees in the House of Commons and the House of Lords. Here you didn't have to justify the public interest, at least not beyond second reading, because once a hybrid bill gets through second reading, the principle of the bill is fixed, and the select committees then go on to consider the bill in the light of any instructions given to them by the House of Commons. But the justification was clearly very strong, the need for strong cross-London public transport links. There had been many unsuccessful attempts to get this going previously, including a previous failed private bill to support economic growth in the city, overcrowding and lack of tube capacity, which until the current pandemic, everyone would have readily understood. The need to provide faster connections from the City of London and the Docklands, both across London and direct to Heathrow, cutting down the very lengthy travel time on the tube to a very acceptable 30 minutes or so from Docklands on Crossrail, at least when it's up and running, and integrate with London Transport tube station works at e.g. Tottenham Court Road and Bond Street. Oops. And there is the beginning of the justification in the Crossrail Bill report, and you'll see the beginning of my opening submissions to the committee, ably supported by a large team of counsel, including the now Mrs. Justice Leven and Tim Mould. This was the preferred route map, and although you will see that it had a series of proposals down to Kingston at the bottom left hand and down to Ebbsfleet on the bottom right hand, and various other stops. The central stops remain the same, but in fact there were significant changes made, and the proposed Elizabeth line, as it's now going to be called, has changed the structure slightly. There's now a station at Woolwich, which we had a set battle with the select committee at one point, and it stops at Abbey Wood heading southeast. It's a pity it doesn't go to Ebbsfleet because I could then catch it, but never mind. And in the west, it goes much further and goes to Reading and provides a much better interchange for commuters, interlink for commuters from that part of the country into central London. South Tees case, well, as you'll know, this arose from the collapse of steelmaking on Teesside at Redcar, a massive site, 1,700 odd acres. As I say, confirmed, it was an inspector's confirmation under the new rules at the end of April. It was underpinned by many factors which justified intervention. Lord Heseltine had reported in 2016, following the closure of the main steelworks, recommending the urgent setting up of a development corporation and the rapid bringing forward of proposals to regenerate, including acquisition. The development corporation was then set up in express terms, and the quotation is from the explanatory memorandum in the SI, to take strategic leadership of the site, to coordinate and drive regeneration in the area. It therefore was given that task, focusing on the promotion of long-term sustainable economic prosperity, commercial development of Tees Valley. It tied in with the local plan. A specific SPD and master plan was produced for regeneration of the whole site. And indeed, the Development Corporation aligned with the Tees Valley Combined Authority and the mayor sits on both the Tees Valley Authority, of course, and also sits on the Development Corporation, and indeed was responsible for driving through a lot of the deals at the last moment during the CPO process. Long-term plans, 20 years plus, so we're not looking at any short-term factor. Government funding for keep safe and remediation and early regeneration works. This was the most difficult aspect of the case because we had to present detailed evidence to show how the funding that was available would be sufficient given market conditions and the likely effect of regeneration on the site, and developing industrial proposals would actually bring forward what was proposed, that is to say, regeneration, employment, economic development. And indeed, there had been a lot of expressions of interest and a lot of negotiations with a number of major operators, some of which are starting to become public now. And so we could show the inspector that not only had a huge amount of work been done, a lot of constructive discussions had taken place, and that the prospects of regeneration, given the government funding that was announced shortly after the general election, well, actually the day after the general election, would be sufficient for these purposes. And indeed, preliminary steps have been taken. I often think that the taking of preliminary steps in acquiring land where possible is a very useful factor to demonstrate the seriousness of intent and the importance of the acquiring authorities' objectives, if it can show that steps have already been taken to get things moving before you even get to CPO. And here you see the massive size of the area running from Redcar in the east to the centre of Middlesbrough in the west, and it is an enormous site. And if you look at the photograph on the left, the L-shaped white building is where we had the inquiry. So the inspector got an eyeful of the site every time he went to the inquiry venue. And that's the master plan. So you can see everything had been thoroughly thought through. And those are the inspector's conclusions from the end of April. And you'll see that he accepted the Development Corporation's case. And indeed, such was the strength of the case that most opposition, even from the Thai banks who were funding the debt on the old SSI land, withdrew. Well, they didn't withdraw their objection, but they didn't actually actively progress it, having sent leading and junior counsel to the inquiry, who sat there, did nothing, and then withdrew. Some failures to establish, a couple of quick examples. Harada, the Shepherd's Bush market case, the inspector had recommended against because the Section 106 hadn't provided the market traders with sufficient protections. The Secretary of State had disagreed. The Court of Appeal, applying a very high standard of reasons, disagreeing with Mr. Justice Dove, quashed the compulsory purchase order for a failure for the Secretary of State to give sufficient reasons for disagreeing with the lack of protection the inspector had highlighted. And indeed, it's fair to say, looking at the decision, that the reasons that were given were fairly perfunctory. The Welsh Streets, I'm afraid one of mine. The Secretary of State disagreed with the inspector, Christine Thorby, as it happens, recommendation that the scheme be confirmed. It proposed to complete an early housing regeneration scheme with partial demolition of some and the conversion of others in a series of basic and poorly maintained terraced houses on the basis a viable alternative of restoration and reuse existed. Now, that was said by the Secretary of State. If I tell you the political dimension to this case, this was a decision by Eric Pickles, picking up the pieces of the John Prescott policy for regeneration of housing in the north. So there was a political tension, which I don't think helped persuade the Secretary of State that he should uphold the inspector's recommendation. There had been a detailed needs assessment, which had been updated and undertaken again for the inquiry. And even that apparently was insufficient to persuade the Secretary of State that there weren't alternatives. SAVE presented a case which the Secretary of State, though not the inspector, accepted, but we managed to demonstrate that their proposals were not viable, as the inspector found. But again, it's always important to remember the political dimensions of some of these cases. The Secretary of State thought that more could have been done. I don't understand how, but there it is. These things happen. These are ultimately political decisions. Aylesbury Estate, well-known example. Secretary of State appeared to apply a stricter version of his own policy than is normal. It's interesting that when Southwark came to challenge the CPO refusal, it was quashed by consent, and the Secretary of State, unsurprisingly, then confirmed the CPO with some cosmetic changes. On alternatives, alternatives is a specific consideration, as I've already mentioned, and it comes in a number of places, and I've listed them there for convenience. It is part of the balance of public and private to consider whether or not the private rights should be interfered with, because there is a lesser way of dealing with the need arising from the public interest other than by compulsory acquisition. Whether or not there is an alternative will depend on a whole variety of factors. And in many cases, if you've got a strong justification for a compulsory purchase order, it will be difficult to show that there's an alternative which doesn't cause disruption, uncertainty, or delay to the implementation of the CPO, and that will often be sufficient, as it was in Liverpool, to see off the alternatives that are being suggested, particularly if you've got multiple alternatives being advanced, which will make a large scheme very unwieldy and difficult to deliver. The European Court of Human Rights in Strasbourg does not require the absence of alternatives to be demonstrated. I'll come to that very briefly in a moment. And you get often this argument, well, we can deliver. And as I've said to you before, we showed the inspector a plan with all the sites on that were said could have been delivered by the individual landowners, just to demonstrate the chaos that would cause the delivery of the CPO. You do have, sorry, that paragraph's repeated, but you do have in cases like the Crossrail bill process, where you have a large infrastructure project which is going through Parliament. Parliament has a much greater opportunity to tinker with the details than can be done at CPO. You've got to be careful at CPO or the CPO elements of DCO, because if you amend the scheme too much, you may end up losing the scheme altogether or having to go back to the drawing board. In select committee, you may have to deliver amendments to the bill proposals and a subsidiary environmental statement to support the amendments. But as we discovered during Crossrail, and the same I suspect was probably true at HS2, there were individual cases, and again, the human element played a very strong part, where members on the committee insisted on changes being made to deliver what they thought would be a better scheme. For example, a new ticket hall at Liverpool Street, adjusting the proposals in Smithfield and the Spitalfields area, and the battle that we had over Woolwich, where I was told by the Secretary of State we weren't going to provide a station at Woolwich. We were thrown out of the select committee, and we weren't allowed back in again until we delivered a promise to deliver a station at Woolwich some months later. The select committee has the advantage of giving its views as it proceeds, as opposed to delivering them all at the end when it's more or less difficult to do anything about it. Just to draw attention to the Bexley case, that's the useful example. That went to the High Court, Mr. Justice Harrison. There, it was a joint call-in and CPO inquiry. The alternative scheme, which was for a Sainsbury's supermarket, was called in and granted planning permission by the Secretary of State with one hand, and then on the other hand, he rejected it as an alternative to the CPO on the basis of delay and uncertainty in the delivery of the regeneration scheme. I've already mentioned the Welsh Street CPO and the Secretary of State's determination that there were alternatives to be found, even though significant evidence had been produced to the contrary. Very quickly, under the ECHR, the short answer to this, as I say to inspectors and select committees and the like in the CPO context, is the ECHR adds very little to what's already in our law and policy for the compelling case. You have the fair balance that requires to be struck under the Article 1 of the First Protocol, which requires a form of proportionality to be demonstrated together with legitimate aim and the other factors. Under Article 8, when you're acquiring homes, of course, you've got to show it's necessary in a democratic society, another form of proportionality. In all cases, you have to show that the public interest outweighs the private interest, and which is precisely the basis of the compelling case test. Leading cases, James, that was the Duke of Westminster's challenge to the Leasehold Reform Act and leasehold enfranchisement, but there you get it set out in detail. Wide margin of appreciation afforded to the national authorities, no required to demonstrate available alternatives. It's relevant but not determinative. And the availability of compensation is relevant, though not absolutely essential. Effectively, you have to get compensation reasonably related to value. And in the UK, that tends not to be an issue because we have the principle of equivalence or fair compensation. See Shunfeng Ironworks and Horn and Sunderland. The Strasbourg court requires compensation to be paid If you expropriate without compensation, that's a breach, but we don't have that in the UK. One example where it's permitted it was the unsurprising exception of German unification, Jahn and Germany. I don't think even Strasbourg thought it was sensible to interfere adversely in the putting together of the proposals for German unification. Calculation of compensation will be interfered with if there's extreme disparity, and there are a number of cases on this, the Vistins case and the Turkey case, where what the national schemes offered was a serious difference between compensation and market value. And in those cases, they found a breach. But as I say, that is not an issue in the UK. And I've already mentioned Tesco and Bexley, Hall and Clays Lane. The courts have consistently confirmed that adopting the approach in national policy, the compelling case in the public interest, means that you are compliant with the human rights case law as well. And in Clays Lane, the Court of Appeal rejected the Samaru test in human rights cases in other contexts, that you had to require the least intrusive option. The requirement of alternatives doesn't require that. And the Court of Appeal was influenced by the fact that in planning and CPO, there is already a huge element of proportionality balancing public and private rights. And there I've set out the statement from Lord Justice Maurice Kay dealing with that particular point. Thank you. I'll now hand back to the chairman, Richard Turney. Thank you.
Thanks, David. I'm just going to run through some tactics, really, from the promoter's perspective in terms of justifying the acquisition of land. I think I've divided it up into preparing for the examination or inquiry process, the evidence, key elements of the promoter case, and dealing with objectors. I think in terms of preparation, my starting point is that you need, in promoting major infrastructure, to keep sight of the strategic case. It applies to every parcel of land that you acquire. You've got to link it into the strategic case. Why is it that you are seeking these powers on these terms in respect of this parcel? It has to be linked back to the strategic reason why you're promoting the scheme. And I think a critical part of all CPO cases, whether that's through a development consent order or through other CPO routes, ensuring the statement of reasons encapsulates that case, at least in summary form. The next point is to avoid viewing land acquisition in isolation. Land requirements may be dictated by scheme design, the mitigation that's required for the scheme, requirements for flexibility across the scheme. And that means that seeing land acquisition as a separate process when you're promoting a DCO, Transport and Works Act order, etc., is a flawed approach. It is going to link to other disciplines, which I'll come on to in a bit more detail in a moment. I think the other point is to establish a negotiation strategy for each group or each objector, because during the course of the examination or inquiry, it's going to be necessary to show a continued willingness to negotiate, even if it's likely to fail. And one of the key points I've found for promoting schemes is ensuring that resources are available to negotiate in parallel to the examination and inquiry. So if your key negotiator is also your key witness, you probably need to delegate some of the work to somebody else. Next point on preparation is ensuring that the hearing team, the advocate, the witnesses and so on, have all the necessary information on each objector. They may not know the details of the objectors. David mentioned earlier the idea of a schedule going through each of the parcels of land. I think that's critically important. Who are the objectors as well? What land do they own? How much is being acquired? What's the history of negotiations? What is the scheme's specific need for these powers in respect of their land? And where is the evidence to support that? And sometimes for a linear scheme, that can be a very substantial job of work, but it's work that's worth doing. And I think another key point that promoters can go wrong in is avoiding assumptions about the nature of objectors. Businesses may be individuals in substance. It may be a one-man, one-woman operation running a small business, and vice versa. You may come across individual landowners who are in fact large landed estates and operating much more like businesses. So avoiding assumptions about who you're dealing with. challenge the need for the land. This is something that I always try to do. Do we need that land? Why can't we accept less? What is the land requirement being driven by? Is it because it is flat under our scheme, or is it because we're not quite sure where our scheme alignment is going to be and we may or may not need that parcel? Could other land be used for the purpose, particularly for things like mitigation planting, construction compounds and so on? And I think assess the risks. How strong is each unresolved objection? And do those objections carry other risks? Because a common tactic of a compulsory acquisition objector is to attack the scheme fundamentals, not just to argue about their own land, but to say there's some wider problem with the scheme that means you should be refused development consent or authorisation under the Transport and Works Act, etc. In terms of evidence, I think in terms of the presentation of evidence, obviously it depends on your process. The inquiry process has the formalities. You're likely to be calling a series of witnesses, whereas the DCO examination, the evidence will often be presented through the advocate with support from witnesses and experts and so on. And I think one of the key points to remember is don't assume that the land and property witness is the right person to defend a compulsory acquisition or CPO objection. The point may be ecology, for instance, if you're looking at mitigation along the lines that Yaaser was talking about. In terms of documents, negotiations trackers are absolutely essential, together with supporting correspondence. You want to know where the file of correspondence is to support the point that is being made. And I think annotating land plans, cross-referencing to the environmental statement, statement of reasons, or wherever you find the justification. So the key elements, and you'll have these already from the previous talks, but the strategic case for the scheme, first of all, why this scheme, why is it here, and why is it being promoted now? How is it supported in policy, particularly thinking about the policy tests, for example, in Section 104 of the Planning Act 2008 for DCO schemes. That strategic case is what underpins your compelling case and is absolutely critical. If you've satisfied the decision maker as to the strategic case, policy compliance, the compelling case should follow on. Alternatives, David's already mentioned this and I just flag it really, but it's worth remembering in the DCO context that you can't just rely on the MPS statement of the need for a particular form of development to address alternatives for compulsory acquisition purposes. Again, a point Yaaser touched on in the FCC environment case, Rookery South. Next, the need for the land and rights in question. Yaaser's addressed this already. I note especially Section 122 of the 2008 Act need to be absolutely clear as to which of those statutory purposes the land is required for, because most examining authorities will ask that question. Negotiations, I always suggest in promoting a scheme you should try to have the last word before an inquiry or before an examination hearing in a letter which sort of records what has gone before and sets out where the promoter thinks they are in the negotiations. Generic letters are better than nothing, but generally don't really show genuine negotiation if every objector has received the same correspondence. Meetings, especially with a cross-disciplinary team, with the engineers, with the principals and so on, are very powerful in terms of persuading the decision maker that you have carefully considered the land and rights required and the interests of the objector. And another point is making sure the decision maker knows about the cases you've settled. It's very easy to go into an examination hearing with 4 or 5 angry objectors and have the sense that there's a huge problem with the land acquisition strategy, whereas in fact you may have settled another 30 or 40, and those points need to be made to the examining authority or to an inspector at an inquiry. So DCO examinations, just very briefly, obviously compulsory acquisition hearings are their own thing in a DCO examination. They must be held if they're required by an objector. It's the only right to be heard under the 2008 Act. More likely in those cases, in my experience, that cross-examination may be permitted, although it's not common, it sometimes happens. However, the process is still XA led, examining authority led, generally without the formal presentation of evidence. I also note always the compulsory acquisition hearings and other issue-specific hearings can't be compartmentalised. There will be issues from those hearings that move between them. You really need to have an overview of all of them. And remember again that an engineer, ecologist or a hydrologist may be needed to justify the acquisition in question. It's not just a surveyor who can answer that question. CPO inquiries, well, there's a wide range of different inquiries depending on the powers being used. And there may be a CPO inquiry alone, but there may also be an authorisation, for example, in the Transport and Works Act provisions. So there's a range of different procedural rules. The evidence is formally led and cross-examined. And I think the key point there, where maybe you're in a multi-day inquiry with several witnesses, is making sure that there's a coherent approach across the promoter experts. The CPO objector may be launching into any aspect of the promoter's case. It might not just be the land negotiations where the CPO objector is going to focus their fire. They may well be looking at the scheme need. They may be looking at, for example, environmental expertise and so on. So making sure there's consistency across the piece. So those are my tips from the promoter's perspective very briefly, and I'm going to hand over to Matthew to take us through the opposite side of the coin.
Thanks very much, Richard. And yes, I'll be looking at things from the opposite perspective now, that of the objector to compulsory acquisition. And I've set out here 4 of the key points that I think objectors can focus on when they're thinking about how to put their case to the acquiring authority or to the inspector considering whether to confirm a CPO. The first is negotiation. And I think this broadly reflects some of the points that Richard was saying. Have reasonable steps actually been taken to acquire your piece of land by agreement? And I think it's worth emphasising how important it is to do an audit yourself of all the correspondence that you've had with the acquiring authority. Does that indicate that reasonable steps have been taken? Do you just have a series of, as Richard referred to them, generic letters which aren't really properly engaging with you? Or are there more specific attempts by the authority? And have you responded to them? Have you adequately engaged? And it's important to emphasise that you must continue to engage even after the CPO has been made, even after the inquiry is started. Often objections get resolved during the course of and even after a public inquiry, but before the decision. And it's really important that you continue to engage as an objector. Otherwise, you'll be criticised by the authority. They'll say that you're the one who's responsible for failing to reach an agreement. A useful tool for objectors can be early information requests. Obviously, negotiations can't take place in a vacuum. It's necessary for objectors to be provided with the necessary information by the authority to enable those negotiations to take place. So getting your requests in early for that information is important. Be proactive. Think about what sort of evidence you need from the authority in order to assess what their case is. And again, you're going to leave yourself open to criticism if you don't make such information requests. Another thing that's really important in negotiations is be very clear about what you want out of the process. There might be, for example, a very specific objective that you have, for example, relocating your business to an alternative site. If you're clear about what you want, it will really help the negotiations. Because at the end of the day, the acquiring authority is really keen to resolve your objection and just get it out of the way. So if you can be clear and tell them what you want, they'll do what they can reasonably to provide it so that your objection can be removed. And the last thing on negotiation is just disputing the compensation offered is often done by objectors, but that itself isn't a basis for resisting a CPO. It's a separate issue. So that's negotiation. The second is alternatives. You've obviously heard from David and indeed Richard on this. From the objector's perspective, you need to think about what the prospects are that you or someone that you're associated with can get planning permission to develop your own land in order to achieve the objectives of the authority. because at the end of the day, CPO is a last resort, and if it can be shown that the CPO powers are not necessary to achieve the objectives of the authority, then that can be a very powerful obstacle to the order. But it's not enough to just come up with an alternative. It needs to be an alternative which is credible. It needs to be realistic, deliverable, consistent with the planning policy objectives that apply to your land and the surrounding area. You need to think about possible impediments to your scheme, to your alternative. And most importantly, if we're dealing with a large scheme which covers a huge amount of land, and your land is only one small piece in the jigsaw puzzle, you need to think about how your proposal will avoid prejudicing plans for wider regeneration, the wider project that's going on. And that's actually more difficult to do than it sounds. Turning to the third point, planning. Although the authority doesn't, of course, need to have secured planning permission, there needs to be no obvious reasons why planning permission might not be granted. And you need to consider as an objector whether the planning policies for the area and also the MPPF, and whether what the authority is seeking to do are consistent with those policies, with that policy framework. And it might be the case, and this is obviously great for you if so, that if your alternative scheme, if you have one, is more policy compliant than the authorities, then this can place you at an advantage. Finally, funding and deliverability. Are all the necessary resources in place to enable these schemes to be delivered within a reasonable timescale? This can be an incredibly fruitful area for an objector to explore. It can sometimes be quite a significant challenge for an authority to establish adequate funding and a reasonable prospect of delivery. Many authorities will be unwilling to provide much in the way of funding evidence. And it's again really important to ensure that early information requests are made for any viability information that the authority might be prepared to disclose, so that you as an objector can understand what sources of funding are relied on, and whether there are any holes in the modelling that's been undertaken and the assumptions that are being relied on. So, I mean, obviously be aware that some information is, of course, going to be confidential, undisclosable for commercial reasons, but there's still plenty of ways to get hold of some information. And if the authority is unwilling to provide that information to you, then you can draw adverse inferences in your evidence to the inquiry. Just 2 points before we move on to the next slide, just to be aware of. Objectors should be astute to check whether the authority actually has the necessary statutory power to make the order in question. I'm thinking about cases such as Pascoe against the First Secretary of State. It's worth looking at the statutory provisions with which the authority are relying on and actually consider whether the order is being made consistently with them. And this is what's known as a vires objection, and it can be incredibly problematic if your objection to the statutory power underpinning the CPO is well made. The second related issue to this, it's almost a preliminary procedural question, is the making of CPOs is obviously subject to a statutory procedure, and it's worth checking to make sure that this procedure has indeed been followed and that the CPO has been validly made, because again, if it's not the case, then that can be disastrous for the authority. Let's go into the next slide. A few other important objector points. Public sector equality duty. The easiest way for an authority to demonstrate compliance with the duty is, of course, by publishing an equality impact assessment. It's not a legal requirement to produce one, but it tends to be, in my experience, the most common route to demonstrating that the duty is being complied with. Note that it's only a duty to have due regard to the need to address the matters set out in section 149 of the Equality Act. It's also worth having a look at paragraph 6 of the CPO guidance, the government CPO guidance. And it's worth looking into whether the CPO is going to have a disproportionate effect on people from, say, ethnic minorities, the elderly, those with a disability. And as David rightly pointed out, this was a very live concern in the Aylesbury Estate CPO. After the first inquiry in 2015, the inspector recommended that the CPO not be confirmed. And that was in part because the council's policy was to require leaseholders, if they chose to purchase a property via one of the rehousing options, to contribute everything they owned, save for £16,000 of their savings and investments. And this was seen by the inspector to disproportionately affect those with protected characteristics, not unjustifiably. And that was why, after the inquiry was concluded, the requirement was removed. There was also an issue in the Shepherd's Bush Market CPO in 2013, which was the subject of litigation in Harada, another case that David mentioned. Many of the market traders had protected characteristics that were adversely affected by the regeneration. Just touching briefly on human rights, David's already covered this, to be honest, and I think he's right in saying that there's not an awful lot that's added by way of human rights to the CPO regime because of the domestic policy requirement for a compelling case to be demonstrated. So that's that point. And then finally, the last point I want to cover is, has the authority justified the need to acquire all of the land in the order? And it's worth saying that while there may be a case for some or even most of the land to be acquired in relation to a scheme, an objector may succeed where it can be shown that their specific piece of land is not necessary to deliver the objectives of the compulsory acquisition. This is linked, of course, to the consideration of alternatives. It may be that a private sector solution within a particular part of the land, subject to the order, can be pursued and integrated with a wider CPO. However, as I said, in relation to alternatives, to succeed with an objection like this, it must be shown that a severance of the land within the CPO is not going to prejudice the comprehensive delivery, i.e. non-piecemeal delivery of the scheme across the whole area covered by the order. So that's a quick canter through some of the key points for objectors. It's also worth saying that it really it's all feeding into the test, the fundamental test of compelling case that David set out. And just a final piece of advice: it often happens that objections blandly assert that the compelling case has not been justified. And I think the most important thing to bear in mind is that you can be much more effective in demonstrating that a compelling case hasn't been met if you go through some of the channels that I've been discussing before, attacking the negotiations, attacking the consideration of alternatives, rather than just, as I say, asserting that there's been a failure to demonstrate a compelling case in the public interest. So hopefully that's been useful, and I'll now hand back to the chair, Richard Turney, to deal with any questions.
Thanks very much, Matthew, and thank you to all our speakers. We've got a few minutes left and just a few questions, so we'll try and pick them up. David, the first question that we received was about biodiversity net gain and whether you can justify acquiring land on the basis that you're going to deliver net gain. Could you give a view on that, please?
Well, the difficulty with biodiversity net gain is that there is as yet no national policy that requires it. The NPPF provisions on biodiversity encourage it, but the bottom line is you apply the mitigation hierarchy, of which biodiversity net gain is not part. Of course, if it's become part of a development plan proposal or emerging development plan proposals, that might be different. Although it is equally right to record that, contrary to the recommendations of the examining authority, the Cleve Hill solar farm case, the Secretary of State did include some land for biodiversity net gain. I can't really speak with any degree of independence about it, because Cleve Hill's about 10 miles that way. and local residents and my neighbours are up in arms about it, as you can imagine. But it's difficult to see how you're going to justify it without a very clear case. But the objectors in that case didn't see it as sufficiently important to, at least I don't think they have, to challenge it. I think if you are going to seek it before the bill becomes law and biodiversity net gain becomes a requirement for all planning permissions, other than the narrow exceptions that are proposed, it needs a rather firmer basis than just a wave of the wand and saying it would be a good thing. That's not a proper justification under paragraph 12 of the guidance, And I can see it coming unstuck in the High Court if it is a major issue and it lacks that firm underpinning. The position will change, of course, once the biodiversity net gain provisions in the Environment Bill become law.
I'd just add on that, I think one of the issues from my perspective is that the way people are looking at net gain is not looking at delivery on site necessarily. And that means that it's quite difficult to say that you must deliver your net gain plot here on this person's land against their wishes, when you can enter into, under the new provisions, enter into a conservation covenant for the delivery of net gain on land somewhere down the road. So it does seem to me to be a difficulty. Certainly on Highways England schemes, I know an approach has been taken to say, well, land isn't being acquired for net gain, but there may be land that is required, for example, for mitigation planting or for landscaping, which can then be used to deliver net gain across the scheme to meet the internal policy of delivering that. Just to pick up a question about parameters and using parameter plans, I think it is a difficulty when a promoter is seeking flexibility and seeking broad parameters for the delivery of their scheme. But it's really a question of justifying the overall potential land take and showing that the parameters are reasonable and reasonably required. But there is a risk that if a particular plot is on the edge of parameters and would only be required in certain circumstances of detailed design, that your justification starts to erode a bit. It's similar, I think, to sort of limits of deviation in linear schemes, but perhaps care needs to be taken in ensuring that you're not too greedy in your parameters and can actually justify the global extent of the land acquisition.
Well, that's a bit like the justified parcels in any CPO that doesn't rely on that sort of approach. You do have to show that the extent you're acquiring is that is required in the public interest, and so if you draw it too widely, you're going to have problems.
Yeah, absolutely. And then I think we had a question about local authorities using CPO powers in slightly different circumstances, for example, in protecting historic buildings. There are specific powers that might be relevant to those sorts of circumstances. So there's a compulsory purchase power in the Planning Listed Building Conservation Areas Act, which allows the local authority to acquire listed buildings in certain circumstances, effectively for their preservation. But it's still subject to those overarching principles about showing that there's a compelling case. So you don't get away from that simply because you're using the provisions sort of defensively. In terms of flood risk, which was the other example that was given, local authorities probably might look to the Environment Agency, who do have compulsory acquisition powers, and use them for flood risk purposes on a regular basis as a potential source of those powers. There's a final question just come in that we'll just pick up here because of its currency, really. For a transport scheme, what does COVID-19 do to the compelling case? Quite an interesting point. I was discussing it yesterday with a group of people. Any views from the panel on that?
Well, I think, isn't it going to be down to the evidence as to whether there's a risk of long-term change or whether the case still exists? I mean, if you think about the Crossrail case, we said confidently in 2005 that the tube would be over capacity significantly by 2020, 2021. And certainly that was the position in February. You'd expect the Secretary of State to take a fairly broad view, and the other point to take is what the political dimension is likely to be if you go for confirmation with the Secretary of State on an infrastructure scheme which is based on pre-COVID planning. The Secretary of State is going to have regard to the fact that it is government policy, and indeed frequently stated, of getting things up and running again. So I can't imagine that the stomach in government for saying, oh, well, if this is all collapsed and therefore we don't need to acquire for this project anymore, is going to be fairly limited.
The DFT have fascinating statistics for every day since the COVID crisis started compared to normal traffic levels on roads, rail, buses. And on Monday, road freight was up to normal levels. Private car usage almost at normal levels, I think 90%, something like that. But it's the public transport that's still well below, down to about 20%.
Yeah.
I mean, my thought on it was that when you're dealing with a DCO case, you've got a very strong statutory duty to determine effectively in accordance with the NPS, National Networks NPS will be the relevant one. And you can't question the merits of that NPS. And it says there's an ongoing need for improvements across the network and delivery of more capacity in every aspect of the network. It's slightly more difficult to try and chip away at that by saying, oh, well, COVID changes everything, because that's questioning the merits of the policy. It might be an easier argument if you're an objector where you're relying on local plan policies, for instance, which may be aged anyway. We're coming to the end. I know there's a few more questions, but I think we'll probably wrap it up there because we've overrun by a few minutes already. So thank you. For those that hadn't answered their questions, we'll pick them up offline with you. I'm sorry for closing, but thank you very much for joining us today. Thank you again to our panelists for their contributions. And please do tune in either live or after the event to the other seminars in this series, and we hope you find them useful. So thank you very much. Goodbye.
Thank you.